I was reading the next steps that need to be taken. Some education. What happens next after this nomination?
Well, if you look at the mandate of the president, the power of appointment is clearly stipulated in Article 144 of the Constitution, particularly Clause 1 of 144. The president makes this nomination or appointment, I should say, acting in consultation with the Council of State and with the approval of Parliament. That's it. In the case of the Chief Justice, the president only consults the Council of State and notifies Parliament, and the Speaker and Parliament will take over from there to do the necessary, what has become known as vetting. And thereafter, when Parliament decides, the decision is communicated to the president, and the president will only do the needful.
So he has to go through two other things, because I realize it's been forwarded to the Council of State. He has to go to Parliament for vetting. Do you see a hurdle anywhere?
I see no hurdle. Absolutely no hurdle. What is going to be the hurdle?
Not even in Parliament?
Oh, the Parliament will do what is necessary to ask the necessary questions, as is usual of this kind of appointment, and that's it. I have no doubt that Parliament will overwhelmingly approve the president's nomination.
Because the MPP has been clear on this. They are not in favor of, in fact, they have issues with the process that led to the removal of the former CJ, and still insist that there's a need to reinstate her. So does that not necessarily say that they will not back this nomination?
Whether they back this nomination or not, we will have a Chief Justice.
Well, we look forward to those processes, but there's one other thing that's related to that, because I was just talking about the former CJ. The last time we spoke to you, she had gone to court. No, I don't think we even took your opinion on that. But she had gone to court raising issues with them. Her issues are simple. Her issues are that if you remove her as Chief Justice, you have to remove her as Justice of the Supreme Court. And I'm sure you've read what has been filed by the Deputy Attorney General. What do you make of both the Chief Justice argument and what the Deputy Attorney General is raising?
Well, honestly speaking, I've just seen the process filed by the Deputy Attorney General. I just saw it this morning. I'm totally unaware, but I'm not surprised. I keep asking a very simple rhetorical question. Not thinking as a lawyer, but being a logician. At least there is some little bit of logic in law. Although some legal positivists will say that law is devoid of any other consideration, including logic. It is never true that there is no logic in law. There is logic in law. The law must be consistent and make sense. I say this because I keep asking the question: have you ever heard about a building that has collapsed with the ceiling still standing?
A building that has collapsed with the ceiling still standing?
Yes.
That's virtually impossible.
So that is what we are being asked to accept now, that the building has collapsed, but the ceiling is still standing. I don't intend to say more, but given the fact that the matter is still in court, but at least the public also needs to know, without sounding any prejudicial. Immediately the action for judicial review was filed in the High Court by the Chief Justice. I haven't seen the details of the processes, but we all know what judicial review applications before the High Court and even the Supreme Court entails. Clearly, I saw a red herring. The red herring clearly is that this is a constitutional interpretation that has been wrapped up cleverly as an action for judicial review in the High Court. What I mean by that is that the issue before the High Court would necessarily entail an interpretive act of the Supreme Court, which act will take the matter out of the jurisdiction of the High Court. And so the High Court, on its own motion, even without an application by the Attorney General or any of the sides, the High Court judge on his or her motion could have raised these issues of interpretation and made reference to the Supreme Court for determination. And so what the Deputy Attorney General has done is in keeping with the spirit and letter of the Constitution, Article 130 plus 1 following. That is to say that any action before any court or tribunal where an issue of interpretation of the Constitution arises, the court or that forum or tribunal will have to stay further proceedings in the matter and refer the interpretive issue to the Supreme Court for determination. I think that is what the Deputy Attorney General.
I see. So for you, this was always going to end up at the Supreme Court.
I knew it from day one because I wondered so much how the High Court was going to determine the issues of whether the removal of a Chief Justice did not affect the Chief Justice's position as a member or a justice of the Supreme Court and a justice of the Superior Court for that matter. The High Court definitely will have no position in determination of that issue.
And I wonder if you see the matter being taken to court by the former CJ's lawyers as a strategy.
It was a trap actually set. It was a trap set for the High Court to fall in had the Attorney General not raised this issue and had judge also out of inadvertence or probably incompetence ignore such a trap and falling into it. The former Chief Justice lawyers smiling to the Supreme Court to quash such a decision.
I see. Very interesting. But would that have had any effect at all?
Of course, if the High Court had overlooked this or both parties ignore this fact that there is an interpretive issue involved and the parties at the court proceeded to make a determination one way or the other on the substantive matter, obviously that decision, whichever way it goes, will be amenable to the supervisory powers of the Supreme Court for determination. That decision may be quashed if it is found out that the High Court judge had acted without jurisdiction and attempt to interpret or find a meaning what this belief actually entails.
I see. Well, let me then conclude with you on this matter of the MPPs. Then I don't know if you followed, but even if you didn't, the major issue they are raising is with harassment. And I'm sure you've heard the cases that they've mentioned. They refer to Abronye DC's arrest. They've talked about some activists who said things that were picked up by the Ghana Police Service. They've also talked about Chairman Wuntumi's arrest, among others. Do you think they have grounds enough to say that they are being harassed based on those arrests?
I think that the slave master always fails at appreciate the pain that the slave took. The slave master never appreciates the pain that the slave took. For MP element to talk about harassment at this time, it's mind-boggling. It is surprising, it's shocking, say the least. At least today we don't see hooded men in uniform, in military and police vehicles, with butter in their hands, well built, marauding everywhere and harassing people. We don't see that anymore. Calling themselves national security and what? We don't see that anymore. The state-sponsored terrorism, violence that has consisted of Ghanaians over the last 8 years. We don't see that anymore. Who are the persons being harassed? They mentioned Chama Wuntumi. Has anybody complained that the offensive for which Wuntumi was suspected and therefore invited and probably detained and subsequently granted bail were not offenses known to our law? So that no offense had been committed or suspected to have been committed at all. In the case of Abronebi, was he not alleged to have committed an offense known to our laws for which the state law enforcement agencies were entitled to invite him or to arrest or to prosecute? They are facing various cases of crime or offenses under investigation or under some have been even put before court. So where is the harassment? Where is the harassment?
You don't see.
Although he has become such a renegade, my brother, when the full issue came up, I myself, I was at the police headquarters. I represented one of the victims. The victim was a person, a group of young men who rushed to the police headquarters just in solidarity with Okuajido. One was beaten to death and was detained. He was virtually carried unconscious to the police hospital. That was the individual I represented. So that get his freedom after having been beaten up to unconsciousness and rushed to the hospital. He was still detained for close to 3 days without charge or trial. What did Poku say at that press conference at the International Press Center? That history will repeat itself. I remember very well what he said. History will repeat itself. That was the statement. And hell broke loose. We're talking about harassment. We cannot count. It is not a retaliatory kind of thing. It is a law-based institution. Anyway, they are free to complain. They are free to demonstrate. At least at this time, nobody is rushing to court to have audit to restrain lawful demonstration. People are demonstrating freely, even against government. Persons known to be part of the government are even demonstrating against the government without restraint. They are not being beaten. Not too long ago, you remember what happened at the 37 military hospital area there when the people country and the other persons demonstrating in threat of this galaxy and environmental hazard that they are causing. Look at what they went through. They were beaten up. They were arrested, detained. Nobody arrested them until they demonstrated peacefully and went home peacefully. So it is fine. It's all part of the freedom of expression, and let them have their freedom, but let the state help over.
I see. What about the point they make that some of these arrests have to do with freedom of speech? The speech is guaranteed under the 1992 Constitution. They should have the right to speak without necessarily being arrested and dragged before a court of law.
They are sounding like persons who don't read the Constitution very well. These fundamental freedoms enshrined in Chapter 5 of the Constitution are not untrammeled, they are not unfettered, they have restraint. Otherwise, there will be chaos. There is no freedom that is absolute. All freedoms are clawed back one way or the other in order to guarantee the general peace of all. Otherwise, an unrestrained freedom leads chaos.
I see. Lara, always a pleasure talking to you. Thank you very much for speaking to us.
It's my pleasure to say now. Have a very good day.
Lara David Ametefe, private legal practitioner, join us on the line, speaking to us on three things, like we said. But what do you make of, first of all, the nomination of Justice Paul Bafo-Boni? Lara says it's not uncharted territory for him. Is that